And at the time, in a House report, the House Judiciary Committee explained, I'm quoting, "Because the issue of impeachment is of such overwhelming importance, the committee decided that it must receive authorization from the full House before proceeding on any further course of action. Because impeachment is delegated solely to the House of Representatives by the Constitution, the full House of Representatives should be involved in critical decision-making regarding various stages of impeachment." Here, the House Democrats skipped over that step completely. What they had instead was simply a press conference from Speaker Pelosi announcing that she was directing committees to proceed with an impeachment inquiry against the President of the United States. And Speaker Pelosi didn't have the authority to delegate the power of the House to those committees on her own. So why does it matter? It matters because the Constitution places that authority in the House and ensures that there is a democratic check on the exercise of that authority, that there will have to be a vote by the full House before there can be a proceeding to start inquiring into impeaching the President of the United States. One of the things that the framers were most concerned about in impeachment was the potential for a partisan impeachment. A partisan impeachment that was being pushed merely by a faction. And a way to ensure a check on that is to require democratic accountability from the full House, to have a vote from the entire House before an inquiry can proceed. That didn't happen here. It was only after 5 weeks of hearings that the House decided to have a vote. And what that meant at the outset was that all of the subpoenas that were issued under the law, the Supreme Court cases I discussed, all of those subpoenas were invalid. And that is what the Trump administration pointed out specifically to the House. That was the reason for not responding to them. Because under long-settled precedent, there had to be a vote from the House to give authority. And the administration would not respond to subpoenas that were invalid. Now, the next point I'd like to touch on briefly has to do with due process. Because we've heard from the House managers that they offered the President due process at the House Judiciary Committee. And Manager Nadler described it as that he sent the President a letter, the President's counsel a letter, offering to allow the President to participate. And the President's counsel just refused, as if that was the only exchange. And there was just a blanket refusal to participate. But let me explain what actually happened. And I should note before I get into those details, there was a suggestion also that due process is not required in the House proceeding, that it's simply a privilege. But that wasn't the position that Manager Nadler has taken in the past. In 2016, he said, quote, "The power of impeachment is a solemn responsibility assigned to the House by the Constitution and to this committee by our peers. That responsibility demands a rigorous level of due process." And in the Clinton impeachment in 1998, he explained, "What does due process mean? It means, among other things, the right to confront the witnesses against you, to call your own witnesses, and to have the assistance of counsel." Now, I think we all know that all of those rights were denied to the President in the first 2 rounds of hearings. The first round of secret hearings in the basement bunker, where Manager Schiff had 3 committees holding hearings, and then in a round of public hearings to take the testimony that had been screened in the basement bunker and have it in a public televised setting, which was totally unprecedented in any presidential impeachment inquiry. In both the Clinton and the Nixon inquiries, for every public hearing, the President was allowed to be present by counsel and cross-examine witnesses. But the House managers say that's all right because when we got to the 3rd round of hearings, after people had testified twice, then we were going to allow the President to have some due process. But the way that played out was this. First, They scheduled a hearing for December 4th that was going to hear solely from law professors. And by the time they wanted the president to commit whether he would participate, it was unclear. They couldn't specify how many law professors or who the law professors were going to be. And the president's counsel wrote back and declined to participate in that. But at the same time, Manager Nadler had asked what other rights under the House Resolution 660, the rules governing the House inquiry, the president would like to exercise.